Kevin Quinley, aka the Claims Coach. This coming week I will be speaking on a panel in Orlando, Florida at the CLM mini conference on coverage, bad faith, and fraud. And this got me to thinking about reservation of rights letters. And I'd like to comment on that and offer 6 tips for claims people on improving their handling and finesse in dealing with reservation of rights letters. Tip number 1 is to drop the legalese. Please be advised, it's fine for foreign films to have English subtitles, but your reservation of rights letters should not need such subtitles. Put it in plain English. When you spout legalese, we all like to think that, we're attorneys, or that through osmosis we've picked up some of the lingo. It puts people off. It's going to be a tough enough sell to begin with. We'll come back to ways to finesse that, but try to purge your reservation of rights letters of all legalese. Put it in plain English, because people feel adversarial when they read heavily stilted legal language in the reservation of rights letter. So even if you are an attorney, even if you happen to have legal training, it's a reservation of rights letter. Put it in plain English. Cut the legalese. Tip number 2 is to cushion the blow. I have learned, sometimes the hard way, that people react to news better if you don't hit them with it cold, but if you prepare them for it. I think that it's often helpful, before you send that reservation of rights letter, to call the policyholder and let them know what's coming. Let them know why you have to do it, and to invite them to call you back if they have any questions or concerns. But when you spring things on people, their reaction tends to be much more negative. So I think that before you mail out or email out any reservation of rights letter or have it delivered, reach out to the policyholder by phone, let them know it's coming, and explain what's coming, which leads to my 3rd tip, which is explain the context. Explain to the policyholder how simply by reserving rights you are not necessarily denying coverage. Explain why you have to reserve rights. You don't have to get into big waiver and estoppel discussion, but explain why this is a formality, perhaps something that you have to do. It's one of those situations where it's better to have it and not need it than need it and not have it. You can always rescind one later if you find out there's no coverage issue. But if you don't do it and later find out that there is a coverage issue, you may be prevented from asserting any coverage defense. So I think it's important to explain the context. Otherwise, policyholders oftentimes think, oh my God, the insurance company is denying my claim. That's not necessarily the case. They may think that the insurance company is denying me coverage. That's not necessarily the case. In fact, many times it's simply to protect the record, to protect the adjuster, protect the insurance company, just in case, but it doesn't lead to a full-blown denial of coverage. I think that's important context to set with the policyholder. Tip number 4, pick up the pace. Once you send a reservation of rights letter, it's sort of like the NFL draft, where Roger Goodell recites the name of the pro team and says, "You are now on the clock." As an adjuster who's issued a reservation of rights letter, you are now on the clock. You've got to decide. You've got to sort of, move or get off the pot, so to speak. So make a decision. Reservation of rights letters have a limited shelf life and sell-by date. You don't have an infinite amount of time. And I can't, in this video podcast, give you any magic formula as to what is a reasonable amount of time. It may vary by jurisdiction. You may need to seek the advice of local counsel. But you need to make a decision. You need to realize that once you reserve rights, it buys you some time. It does not buy you unlimited time. Act with a sense of urgency and dispatch to gather the information that you need to decide which fork in the road you're going down, whether it's toward claim denial or claim acceptance. But you're on the clock, pick up the pace, and understand that it is time sensitive. Number 5, try to build customer goodwill. Even if you are successful in thwarting any bad faith claim as a result of a reservation of rights letter, you also want to pursue the aim of retaining customer goodwill. That even if they don't necessarily agree with everything, they understand where you're coming from. The broader issue, what we're trying to do as claims people are a couple of things. Number 1, obviously we want to avoid bad faith risks. Those can come with monstrous financial liabilities. But beyond that, or short of that, we also want to make sure that we deliver quality customer service, and at minimum, don't alienate customers. If you handle or mishandle in a maladroit way a reservation of rights letter, even if you dodge a bad faith claim, it is possible that it can still leave a bad taste in the mouth of the policyholder, who ultimately says, in the words of Taylor Swift, toward renewal time, "We are never, ever, ever getting back together." That's not what you want. You want to make sure that you build relationships so that policyholders stay with your company again and again and again. So aim not only to avoid a bad faith claim, but aim to structure the relationship and the communication exchange with reservation of rights letters so that you salvage policyholder goodwill or at least understanding. Finally, number 6 tip is ask yourself, do you really need to reserve rights? Here's where I'm coming from. There are situations where there may be textbook or theoretical grounds for reserving rights, but the odds of those becoming viable coverage issues may be infinitesimal. Let me give you a couple of examples. Maybe a plaintiff attorney has thrown in an allegation of punitive damages, just sort of as a kitchen sink kind of claim. There appears to be no basis or viability for the punitive count. Maybe the policy excludes coverage for punitive damages. Maybe you're in a jurisdiction that does not allow insurance coverage for punitives based on public policy grounds, whatever. Do you really need to reserve rights on that? Second example is where there may be some technicality regarding late notice to the insurance company by the policyholder. Maybe you're in a state which requires that the insurance company prove prejudice in order to use that as a valid basis for denying coverage. In my experience, in those types of situations and jurisdictions, winning a coverage defense based on late notice is very much a long shot. Now, here's what I'm saying. There are certain times where you may feel that you're being goaded by the policyholder or the policyholder's hand-picked attorney who wants to handle the case, that you're being goaded into reserving rights so that it will create a cumulus type situation where the insured is entitled to counsel of its own choice, but you pay for them. You may be opening the door, you may be opening the Pandora's box to insured's counsel, which frankly is ready to rape, plunder, and pillage on the billing side of the file, and you're going to relinquish a lot of your ability to control the transaction cost of that case. And it could be that that risk of relinquishing that ability to control the expense side may be greater than the theoretical possibility, but remote possibility, of having to face a coverage issue. So all I'm saying is that you've got to approach those carefully. There may be situations, and I've been there, where we've made a strategic decision to consciously forego reserving rights because we wanted to preserve our ability to manage and control the defense. That's going to have to be done on a very selective case-by-case basis, but I think that there are situations where that is viable. Those are 6 quick tips on handling reservation of rights situations. You may have some more. If you find these tips of use, then please feel free to stop by my website at claimscoach.com, reach out to me at kevin@kevinquinley.com, or give me a call at 804-796-1939. Take care, and best wishes for you.